Janab PP Mohammed Fazal.
Thank you very much, Chairman Sir, for allowing me, and thankful to my party for posing faith on me on this, raising this, supporting this bill. The High Court and Supreme Court Judges' Salaries and Conditions of Service Amendment Bill 2021. My learned friends, senior colleagues, almost all advocates, senior advocates have spoke very thorough into the aspects of the bill. And I am not repeating what my learned friends have already elucidated here. We all know the legislative intent behind this bill is for awarding benefits, additional quantum of pension to retired judges from the first day of the month in which he completes the age of specified in the first column of the scale, and not from the first day of his entering of the age. So on that, Pinaki Mishra ji have very well, put his point, the competency of the bill. See, there is no doubt among us that this kind of service of the judges of Supreme Court and High Court to the nation. And it is our duty to give whatever the possible extent, the kind of service they put to benefits for them. There is no doubt on that. At the same time, we must also, government should also think about the proportionate pendency of the case and the vacancy as of now in the country. See, the pendency of the case, when we start talking on that, the justice which wanted to deliver on right time, as our constitution says that justice delayed is justice denied. This directly attributes to the pendency of the vacancy to be filled up. In Supreme Court, in High Court, in subordinate courts, there are lakhs and lakhs of cases pending for want of justice. So this is an alarming situation that Government of India should take a call. The sense of the House is that whatever the best method which we can adopt for easy filling of the posts of the judges in the Supreme Court and High Court will deliver justice to the common people. We must also think of, alternate dispute redressal forum also. Before entering into the court, the government must also promote the alternate redressal system, dispute redressal system, so that the common man can get the justice before entering into the court. And the pendency of the case can also be brought down to the minimal by technological upgradations, like modernization of the court. The formalities of filing a case in the court, not many papers, by hard copies. Nowadays, after pandemic situation, it has become online, but system should be developed in such a way that the technology upgradation, which is now the country is being fond of, must be utilized for getting the easy justice and the easy procedural things from the courts. Sir, also we must also think that unnecessary executive orders, which attracts the people to go to the court. For instance, in Lakshadweep, my constituency, nowadays people started rushing to the court in the High Court. You know that what is happening in there. See, the Law Ministry have released a circular very clearly saying that if anybody, any state or union territory wanted to bring in a piece of legislation, the circular says that the pre-legislative consultation process must be taken in place before making the piece of law. So the Lakshadweep, what happens is, I'm being the lone member of parliament from there. There were a slew of piece of legislation which attracted wide protest from the people across the party. What was the reason? Because there was not a single pre-legislative consultation happened in these cases. Be it is enactment of PASA regulation, where what is the requirement of PASA regulation in Lakshadweep? Where the Home Ministry's crime bureau record says that the case is zero in that island, where no object and reasons have taken into place, and all on a sudden, administrator decided that a PASA regulation should be implemented there. I'm thankful to the Home Ministry that Home Ministry still frees that all those parts. But the point is that on that, people are forced to approach the court, again adding to the pendency of the court. Now Lakshadweep has become an area where democratically no one can protest. Even a case is registered against me when I protested against the price rise of helicopter ambulance, which was normally, when the government is not putting the things in place in the hospital, the patient are supposed to be evacuated by helicopter. And the helicopter is supposed to be a free ambulance. On that, the price 100% hike. A patient has to pay minimum 20,000 rupees before he go for the treatment. See, such things, when we protest also, under Article 90, which gives us power, the Constitution gives us power. If you go for protest, the FIR is against, files against, for that again we are going to the court. So all these unnecessary executive orders also need to be noted by the government. And there was attempt from the Lakshadweep administration, precisely when this present administrator took charge, to change the jurisdiction of the court of High Court of Kerala.
Article 19 gives you the right.
Right, yes. Sir, the jurisdiction was tried to change from Kerala to Karnataka. You know that the most populous language, the people of Lakshadweep, the language we spoke is Malayalam. And the conduct of court proceedings will be easy for us in Kerala. And thinking that the previous government, and the name of the court is that the Honorable High Court of Kerala and Lakshadweep. And an attempt was tried to change the court from Kerala to Karnataka. And Honorable Law Minister have got a start question on that. He has to answer for that. There was not such, but because of the protest, it was dropped. So my point here is that unnecessary executive orders also contribute or piling up of the case. So finally, I always support this bill from the side of my party. And thank you so much, sir.